Hey, everybody. Welcome back to another Wednesday night live from Courtroom Confidential. So glad that you all could join us. We know that there are other true crime streaming channels taking place around the same time. We're still working on trying to coordinate that so that we don't put all of you folks in a position of where you have to choose between your favorites. But it's a work in progress. We're trying to find a time that seems like it will work with everyone, but we really appreciate you guys being here as we continue to try to grow this channel and continue to make Wednesday Night Live something that you guys look forward to. I look forward to it because a lot of stuff happens between every Friday show. And it seems like, God, we're going to forget about that, or there's going to be too much on Friday. So let's make sure that we take advantage of this midweek check-in so that you guys are caught up on everything that's going on, and we have a chance to actually interact with you and hear your thoughts on these cases. So I hope you all had a wonderful week in the meantime. As far as news that's going on with us, well, first of all, I hope everybody is okay in Florida. I hear Hurricane Helene. I just saw a weather report that it is due to hit Florida late Thursday. So if you guys are in Florida and you're boarding up the windows and preparing and mixing a batch of hurricanes, please let us know that you're okay. I've never dealt with a hurricane. I was born and raised and lived in California my entire life, other than a short stint in Chicago for about 4 years. And the only thing you got to worry about in Chicago is tornadoes, and none of them ever bothered me while I was there. But here in California, we have to worry about earthquakes, and I don't know which is worse: the idea that you know something's coming and you have to prepare for it, or the idea that you never know when it's coming. I think I probably would prefer hurricanes. That's probably a good poll question. Which is worse in your mind, hurricanes or earthquakes? Hurricanes, I feel like you get them every year, so you have to deal with them. Earthquakes, you don't get them every year, but you have no idea when they're coming, and they're always at an inconvenient time. And when they do come, you never quite know, is this one just kind of a, do I need to even get up off of the couch, or is this a big one? Anyhow, if you're doing well, you're in Florida, we hope you're well. Our thoughts, our prayers are with you. Stay safe. As far as news with us, the big news. The baby's in the house. The baby's doing well. Both mama and baby are all happy and healthy. Baby, I will say, has a healthy set of lungs on her, because when she wakes up in the middle of the night, it is a piercing cry that she does not let off until she is back to, being fed and having her diaper changed and all comfortable. And then she goes right back to sleep. So she's a happy kid and everybody's doing well. I will say, in just kind of a gossipy side of things, to keep you guys clued in, I know a lot of you, we had asked, we had Matt Murphy on last week, and I thought that was great. I love Matt. He's fantastic. A lot of you really appreciated that. And it was our first kind of experiment in having somebody on this live show. And I hope you enjoyed it as much as I did. And we asked you guys, who are other people that you wanted to hear from? And a name that has come up, and I'm not making any promises, but I am kind of teasing this, is Alan Jackson. If you guys know, I think I've talked about this before. I've known Alan for close to 20 years. He is a mentor of mine. I was his law clerk back in the Phil Spector days. And he is an incredibly busy man. Defending Karen Reed has become kind of his career case at this point. But him and I did actually touch base. He sent some very nice well wishes regarding the new baby. But, I talked to him. He knows what I've got going on. He's super busy and knee deep in crocodiles dealing with Karen Reed and all of that. But at least we have touch base, because I know that's somebody that you guys would like to see. And again, I'm not making any promises. It'll probably be like pulling teeth to get him to do something like this, but at least we have chatted. All right. That is all the kind of news. I wanted to give a special shout out, though, to we do this live, and then I know it doesn't work out convenient as far as time for a lot of people, but we get a big group in the replay crew. And I want to give a shout out to those folks, because it's, as much as we have fun on the chat, the live chat here, they have a lot of fun in the replay crew, commenting and contributing to this community as well. And I don't want anybody to feel ignored. So Helen Culver Steiner, Lacey Lace, Bianca 4931, and Nettie 3485. I see you. I heard from you. I appreciate you. Thank you guys for being a part of all of that. And you know, again, memberships are open. We are really trying to make sure that that is something that you guys feel like we are contributing towards. And so I wanted to give a shout out to our new members, our renewing members. If you guys haven't joined up, please check it out. It's a program that we're very proud of and trying to keep that going. All right. Yes, Jedi Platypus, the replay crew does certainly rock. Okay. So some of the cases that I wanted to jump into this evening are, you know, we asked you guys, what are you interested in? Sarah Boone took the prize. Of course, Sarah's got a lot to chat about. If it's not anything legal, it's just talking about her craziness and antics in court. So we'll certainly get into some of that. But there's actually something really interesting. A couple of things that she did in the last week or so, her defense, I should say, her new lawyer, James Owens, did, as far as defense strategy. We'll get into that. We'll also talk a little bit about Ashley Benefield. I wasn't going to talk about her, which is funny, because her whole situation has to do with this idea of a juror and juror misconduct. And usually that stuff, as salacious as it sounds, and oh my God, you know, the jurors read a news report before they deliberated, and we, you know, Karen Reed and all that nonsense, I think, has kind of kicked up the dust on the idea of what are jurors up to in that deliberation room. And there were some allegations of juror misconduct in that case. And I usually think on these things, you know what? I've heard this so many times when I was a practicing prosecutor, and it usually ends up being a big nothing, because people who sit on juries, for the most part, are very, very conscientious, and they do not break the rules if they can at all avoid doing that. But something interesting happened with her case that I actually put it on the docket for this evening, because I thought there might be a little bit of fire where we see smoke in this, and it's worth talking about. But the first thing, after saying, first of all, hello to everybody who is already in the chat. Thank you guys so much for being here. The first thing I wanted to get into is a case that I had not really been following all that much, and I don't know if you guys have, but something really interesting happened in this. And it's so funny, and you guys know this. If you follow true crime news, you will hear the refrain of "you never see this" come out of my mouth quite a bit, because there are things that seem to happen every single week that I think to myself, I've never experienced that before. I've never seen that happen. And that's what's so amazing about being involved in this community, is you really are seeing these incredible true life dramas play themselves out in ways that you never could have imagined, and in ways that are, you know, this isn't television. It's on TV, but it's not television. And it's these and that happened this week with this case of a gentleman by the name of Toby Madden. Okay. I don't know if you guys have been following this one, but just to give you a little bit of background, Toby is accused of murder, of course, from a murder that took place in October of 2022. And that was his girlfriend of 27 years. Her name was Rachel Brushaw. According to prosecutors, she's 50 years old, by the way. He stabbed her in the chest, abdomen, head, knees, arms, shoulders, and hands 50 plus times. So we are talking about a true overkill, a true crime of, whether you want to call it passion or losing your mind or whatever it is. And I got to say this too. We talk about this sometimes a little bit cavalier when it comes to stabbings. You got to think about how personal a stabbing is. How um how what is the word I'm looking for? How visceral it is. It is not pulling a trigger and somebody drops dead 20, 30 feet away from you. It is being up close and holding on to this knife as you plunge it into somebody's body again and again and again and again. And it brings the nightmare and horror of the thing really to life when you start to think about that. You know, we talk about, oh, they stabbed this. That's a lot of physical work, by the way. The think about the time that it takes to stab someone 50 times, to shoot someone half a dozen times. You could get done in a matter of seconds. To stab someone 50 times might be a matter of minutes, which is a very long period of time when you're talking about committing a murder. 50 something times stabbing someone, and then the physical exertion involved in that. Not to get overly graphic about this, but it's exhausting. It's an exhausting amount of labor to stab someone that many times. And I say this too, when we talk about dismemberings, that didn't occur in this case, but when we talk about dismemberings, always remember that, you know, they talk about, oh, and he, you know, cut off the person's head or cut off their lip. That is not, we're not talking about hot knife through butter here. We're talking about physical intensive labor. Okay. I don't want to make us all a little cringy and sick and realize it's around dinner time for most of us, but that's what I'm saying here. When we say 50 times, you really got to think about sometimes what that actually means to have accomplished that. But his defense originally going into trial was someone else did this. Now, leading up to trial, this man has had troubles. He had tried to represent himself a couple of times. He had asked to do that. Kat, thank you so much. That is so kind of you. He'd asked to represent himself a couple of times, been denied by the judge. That's an interesting topic to get into at a later time. How can the judge deny you the right to represent yourself? Well, a judge can, because part of what the judge is doing is balancing your constitutional rights between making sure the trial doesn't turn into a circus and something that's going to be overturned on appeal. So balancing all of that. Then apparently at one point he had threatened to assault his own attorney. So this man is not well, I guess is the nicest way of putting this. He's not well. He may not be playing with a full deck. He's a very troubled man. He committed a very violent and awful murder against someone that he had been with for 27 years. Okay. There's a bunch of other stuff. There's some, you know, a suitcase of meth. Of course, there's a suitcase of meth involved somehow, all of that other stuff. But what I really wanted to get into today was what happened just before opening statements. And I'm going to play you guys this video. Okay. And I'll warn you that the video starts out without sound, but then the sound kicks in. But this is Toby Madden in court as they're getting ready, as all the parties are being assembled to start opening statements. And his family has gathered in court. Everybody's in court. This is not some pre-trial thing. Everybody's in court to see this trial get underway. That's him in the without the suit and tie. Okay. So I don't know if you were able to hear that, but at one point, what he's saying is, "I'm so sorry." And he's obviously having this emotional breakdown in court. The gentleman that you see whose back is to you right there is the prosecutor. And I don't know if you caught it, but he saw what was happening, and he kind of drew attention to it with his co-prosecutor as to what was happening and what was, more importantly, being said by the defendant in court. And what we now know is that he had seen his family members. He had seen apparently his daughter, who's also, I believe, the victim's daughter, in court. I could be wrong on that. And that's who he apparently is speaking to when he's saying, "I'm so sorry." And there's some that we missed because of the audio, and there's apparently some that we missed ahead of time. That the reason why we know this is what I'm about to show you next. Because the question then becomes, as a prosecutor, what do you do with this? What do you do now with this person who's your defendant having an outburst in court? Do you simply ignore it? Do you simply move on? Are you allowed to use it? The answer to those questions is, not only are you allowed to use it, but I think you absolutely need to use it. You should use it. And not to get into the kind of legal weeds here as far as how is that admissible, but this is not testimony. Okay. So it's not like he's sworn and taken the stand and he can be cross-examined on this, but this is a statement by the defendant. And usually, quote unquote, hearsay is out of court statements. So we're obviously in court, but I don't think that's what is meant by the in court part of in court when it comes to hearsay. It's usually talking about a sworn statement versus a out of court unsworn statement, but it's a out of court statement offered for the truth. And that's where you get into hearsay problems. An out of court statement offered for the truth asserted. A prosecutor has to worry about none of that when it comes to the defendant. Everything the defendant says comes in through the prosecutor. Defense can't get it in. Prosecutor can get it in whenever they want because it's considered a party opponent statement, and they can always get that in. So what does he do with this? How do you handle this? We're going to see how this prosecutor handled it. And I like it, and I encourage a little bit more out of it. Let's skip ahead here. So now we're, later on in the day, and the prosecutor's about to begin his opening statement here.
Good afternoon, ladies and gentlemen. As you can see here, I have an opening statement prepared. However, sometimes things happen where you have to change on the fly. So I'm still going to give you this opening statement. However, I'm going to tell you something first up front. So probably 30 minutes ago from now, you all were back in the jury room. Mr. Madden was brought into the courtroom here. Record was on. We had to deal with some preliminary matters before you were all brought in. Mr. Madden saw Michaela Madden in the back of the courtroom, and the rest of family members. And he turned to them and said, as he made a motion of this, I'm responsible for what happened to her. I didn't mean it. I love her. That was recorded, and you're going to hear that recording during this trial. You're also going to hear from witnesses that also heard it. Detective Horton heard it. He was sitting there. Michaela heard it. She was sitting there. He was talking right to her. So you're going to hear that in this trial. And now my plan is to give my opening statement that I did have prepared and explain to you.
Okay. It kind of glitched there, but that's exactly where I wanted it to end anyways. Wow. again, you just don't see this. I mean, it's pretty, listen, I've heard defendants have outbursts in court plenty of times. Usually those outbursts are, he's lying, this is all BS, you know, get me out of here, whatever it is. But it's something where they're attacking the allegations against them. I have never seen a defendant with an outburst in court that had to do with admitting their own guilt in this dramatic of a way. And apparently he has had more troubles as the trial has gone on, more emotional outbursts, not as much of what we just saw here, but just kind of breaking down and having moments where he's just inconsolable and crying as testimony was being presented in court, especially I think it was during presentations of photographs of the victim in this case. And to the point that his attorney asked if he could possibly watch the trial remotely because he simply cannot be controlled, which is an interesting question. And the judge has not allowed that, from what I understand, yet, because he's been present. This was on day one. It's been now day two, I think was today. And he's still in court and still kind of having these emotional moments. And it raises the question of, one, are you allowed to have a defendant appear remotely? And yeah, it's happened before if they're just completely disruptive of the proceedings and the judge needs to maintain some order in the court. Sure, that'll happen. We've seen that happen in other cases before. I think there was a lot of that took place with the Christmas Day parade massacre that was up in Minnesota, I believe. But this reason that they're asking for is basically strategic. It's not that his emotions are causing disruption in the proceedings. It's that they don't want the jurors to see his emotions because of how they realize his emotions are going to affect them. And by the way, that's just fine if the jurors allow their perception of him to play a role in how they view this case. I mean, that is part of why trials take place with the defendant there, is to see their reaction to things, to see, are they laughing inappropriately? Are they responding in an appropriate way to different allegations? That can play a role, and absolutely is a role, in the jurors' heads. It may not be quote unquote evidence, but it plays a role in their heads. And this prosecutor did not shy away from that. I'm glad that he didn't shy away from that. But had I been there to speak with him, and would he have listened to me? Probably no. But had I been there to speak with him, I think he would have said, I think I would have said, no, this is a moment you're never going to get again. Dive into this thing. This is incredible. Let them know what just took place, that before this trial even began, ladies and gentlemen, he admitted to the crime. That's where we're going in this whole thing. You know, it's not uncommon to see trials that essentially end before they begin. When I was a prosecutor, we used to call them long pleas, and I think that's exactly what's happening in this trial. So some dramatic stuff. All right, let's move on to Sarah Boone, because something happened in her case that was kind of interesting, and people have been talking about it a lot online, and I just kind of wanted to give my thoughts so that we're all on the same. We all kind of understand exactly what's happening and how significant it is or not. First of all, James Owens is now her 9th attorney. James says in court at a pretrial hearing earlier, it was either this week or last, he tells the judge, for the record, we are claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense. not accident as they want to allege. The judge was surprised by this and responded, "Are you claiming self-defense?" Well, that's the first time I've heard that. Okay. So already you've got this new attorney kind of pivoting and changing the strategy as far as what he's going to go into. And I'm not quite sure if that's the smartest defense, and we're going to see why, because it's related to the second part of this and the issue that we're going to talk about. But first, let's talk about what he means by that. Battered spouse syndrome is not a defense as much as it's an understanding of how you can extend self-defense. Self-defense involves reasonableness. It's reasonableness in the perception of the threat. It's reasonableness in response to the threat. It's reasonableness in the amount of force that's used. In other words, you can feel that somebody's about to attack you, and you can be reasonable in feeling that you're going to be attacked, and objectively, everyone believes you were going to be attacked. But if your response to that is unreasonable, somebody's coming at you with fists and you go back at them with a machine gun, that can be unreasonable. So that's where that's the world we're playing in, the rules that we're playing with when it comes to self-defense. What battered spouse syndrome does is it actually talks about the immediacy of it all. Because what you're saying is that this person has been suffering from systematic abuse for so long that defense may not be, that threat may not be immediate, but you are living in it so much, it's so in the air, in your environment at all times, that is why you responded in a lethal way when you did, even though you may not have been threatened against your life in that exact moment. That's what he's saying. He's saying we're using battered spouse along with self-defense to kind of cobble together this argument. Now, the problem becomes, has she made statements ahead of time that support that? And the prosecution is saying, no, you did not. The prosecution is saying that you made a statement to investigators of, I didn't have any motivation. She was asked, what was your motivation for leaving him inside? Answer, I didn't have any motivation. It was me. He and I having a great day, fooling around and being stupid, and apparently me going upstairs and going, I'm guessing, I mean, I don't, I'm blaming it on the wine. That does not sound like I was so terrified of what would happen to me if I opened up that suitcase that's why I didn't open up that suitcase. That is, I got drunk and I forgot about him. And that's an accident. And that's exactly against what her defense attorney is saying. And that is why keeping this statement out is so fundamentally important to the defense. I'm going to show you some of the documents, but I know that people have some questions. So, Kaylin, if we have some questions that maybe I could get into now while I'm setting up the documents for this. Okay. The former lawyer's compensation. I know that there was a lot of a hearing on whether or not each of these people got paid. You know what? Get good on them. Get your payday. Get out. I probably, quite honestly, wouldn't have even showed up to court in because of fear of somehow getting roped back into the whole thing. But I did see that hearing. Is Sarah's defense screwed if the interrogation video gets in? Yeah, Kat. I think that's kind of the point of why they need to keep it out. They cannot support their theory on a defense if this interrogation video gets in because of that statement that she just made. And so now we're going to talk about what is it that they're saying about this interrogation that is so bad that the whole thing should be kept out. And it basically comes down to a Miranda argument here. Okay, so do I think the Miranda argument has any legs? Great question. Let's talk about it. All right. This is part of And I apologize for the documents here. If you guys can't read it, I will read it to you. But this is the best document I was able to find on this. And this is her motion as to why the Miranda advisement is deficient. And she's saying that she's brought in, she'd already been Mirandized once. Now she's brought into the station again. And I'm just going to read to you this kind of back and forth between the detective and her. Detective, so I'm going to read you your rights again because we have to talk about that. And we're not done talking about the incident. We just have to do it. Boone, just like we did yesterday, normal protocol. Detective, just like we did yesterday. Remember, I read you the rights. Detective, yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you. Okay. That's true. Every time that they speak to them, good practice, though it's not entirely the law, but good practice is re-advise somebody of their rights. Miranda applies if you have a person who's, it's called custodial interrogation, a person who's in custody, meaning they're not free to go, which is a very good argument for what's taking place here. She's at a police station, probably doesn't feel free to just walk out, and she's being interrogated in that they are asking her questions about the crime. So Miranda would apply here. It's smart to just advise her every time they sit down to speak with her. So then they read her the rights. You have the right to remain silent. Anything you say may be used against you in court. You have the right to have a lawyer before you and during without questioning, without charge. If you cannot afford a lawyer, one will be provided to you. Has anyone threatened or promised you anything to get you to talk? Boone, no. Detective, and you understand what I just read to you? Boone, yes. Detective, perfect, okay. So this morning we went to the autopsy, blah, 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 and they start into their interrogation there, okay? First of all, let me say this about Miranda. That these are not magic words, okay? I think there's this conception, and I get this a lot, even from my own clients. People love to point out the fact of, I was never read my rights, as if there's some sort of magic sauce that takes place in an arrest that you need to be read your rights. Not true. You can be arrested, never read your rights. It's only whether or not they want to use any statement that you're making against you in court that you haven't just blurted out on your own. Okay. So the person who's being arrested shouting about how, yeah, I shot him and I'm glad he's dead, they don't got to worry about Miranda rights with that person. It's the person that they bring back to the station or that they have in the back of the squad car and they want to ask them some questions. That's who they have to worry about with Miranda. And that doesn't mean that the arrest is somehow deficient. It just means that they need to, if they want to get those statements into court, they need to advise that person of the Miranda rights. Miranda comes from a case, obviously, Supreme Court case, Arizona versus Miranda. And it didn't outline these words as magic words that we see here, but it outlined the concepts, the idea that you do have a Fifth Amendment right to not incriminate yourself and therefore remain silent, that you do have that anything you can say, that anything you say can be used against you, that you do have a right to a lawyer. If you can't afford one, one will be appointed. All of those are just advising you of things that already exist. And the idea is, let people know that so that they are well aware before they start making statements. Kat says, Josh, is it about the words being said or about the person understanding? Sarah knows the law. She's been Mirandized in the past. She is aware of those rights. Great question. It's actually both. They read them and they read them in a recorded statement like this so that nobody can go back later and say she wasn't Mirandized. This is CYA 101 for the police. Yes, the more important thing is, does she understand them? Okay, which brings us to the next line of argument here from the defense, which, if you will bear with me, I will try to pull up right now. This is the crux of their argument, okay? They are saying, and again, if I apologize if you can't read this, They are saying that the detective read this from a Miranda card. Almost every officer in the United States has this card. Oh, wait a minute. You guys aren't able to see what I'm looking at. Sorry. Hold on. Oh, Kaylin, save me. What am I doing? Hold on. Hold on. I'll get it. Don't worry. There. Okay. This thing, that image there that you see, Miranda warning, that is a copy of or a recreation of a Miranda card that nearly every officer in this entire country carries around somewhere on their person. And they will literally read from this. Now, why do they read from it? It's not, again, because the words are magic, like some sort of Harry Potter spell that they need to read these words in order to actually conduct a arrest. It's because these words have been vetted by decades upon decades of case law. Miranda was decided in the 1960s. So from then till now, there's been case law on what exactly should someone be advised of. And these words here have ended up being the most solid to avoid trouble if it's read to a person just as this is. But by the way, this card isn't the exact same card that every single officer carries around. Every department has some variation of this, which may have a little changing of the words here or there, but it's essentially the same thing. So their contention here is that he read from this, but what he didn't read is this very last line in this whole thing. The question was asked, and you heard that, do you understand each of these rights as I've explained them to you? But then didn't say, according to them, omitted the final Miranda question, which is, having these rights in mind, do you wish to talk to us now? And they're saying because of that, this is deficient and she wasn't properly Mirandized. My opinion of that is some weak tea. I don't think they're going to get anywhere with that. That is a person who, as somebody asked, has already been Mirandized before, sat there and understood what they were going to be talking about, sat there and understood that what their Miranda rights were, and they got into the discussion. She was asked the most important question probably of all is, do you understand each of these rights? And that question was asked, but the question of having these rights in mind, again, there's no secret formula here. It's not like they're trying to conjure up a genie and you have to say it in a very particular way. That one line not having been read is not going to carry the day with this judge, I don't think at all. But why are they so desperate here? Why are they so desperate to keep this statement out? Because her statement is, we were fooling around, being stupid. I went upstairs and I'm blaming it on the wine. Not a sentence about, I was scared to death. He had been beating me savagely for months. I thought if I opened it up, he would kill me. That is their defense, and their defense is simply not supported by her own statements. And that's where we're going with this whole thing. So again, none of this changes that videotape with her taunting him. None of this changes the statements that she gave to police. And in fact, this doesn't even attack the previous statements that she made. It's only these statements right here. And I'll be honest with you, I think even if the judge were to make some wild judgment and decide that they're not going to allow that statement in, I still don't think that the case falls apart. So that is Boone. Do you guys have questions on that one? Kat says, are there takebacks with defendants like Charlie's sixth waiver was, assuming it once existed? Yeah, Charlie's waiver. No. I mean, if you're talking about if she can she decide to take back this waiver, Miranda, once she gives it? Well, that's a great question too, because the answer is no. If you say, yes, I'd like to speak, and you start to speak, everything you say from that point on is admissible. But at any point, you can say, I want my lawyer. And if you want your lawyer, that's actually a different right. It has nothing to do with Miranda, really. It's about your Sixth Amendment right to counsel. And at that point, they should stop all questioning whatsoever. So much of learning as a prosecutor, so much of what we learned was about how to handle these kind of back and forth interplays with defendants and the statements that they make, because this stuff does happen all the time. They'll be sitting there and they'll get all their Miranda rights read to them, and they'll start talking and they'll realize that, oh, they're not talking about the tax evasion that they originally thought they were called in for. They're talking about the dead body that was found on their property. And all of a sudden they go, should I have a lawyer? And many times detectives will say, what do you need a lawyer for? Well, we're talking about such and such. Yeah, that's all we're talking about. If you want to continue talking to us, is that an invocation of a lawyer? Is that where they should stop talking? Brooklyn says, why would her attorney lead her down this road? I feel for the man. I think he's doing the best that he can with what he's got. And I think he realizes the only defense that he could possibly mount that might have any chance of life whatsoever is this battered spouse. Because otherwise you're left with a person who just left someone to die because they got too drunk. And that's not going to get her out of murder. And so they're left with what they've got, and what they've got, he can't support with her statement. And I'll tell you this, even if that statement comes in, they're probably still going with it. Does that mean that she might testify? I think so. I think she's the type of person who will testify. I think that she has wanted to control this thing from the very, very beginning. I think she'll grow sick of poor James in the middle of trial. I think she'll criticize everything that he's doing. And I think she'll say, I want to take the stand and testify myself. And I will be there for it, because I think that will be a spectacle to watch. All right. Any other questions on Boone before we move on to Benefield and some wrap-up questions? Okay. Now, Benefield, you remember she is the Black Swan murderer who claimed self-defense. Nobody bought it. The prosecution, I thought, did a really remarkable job with her case. And then soon thereafter, it started to come out that there was some sort of jury misconduct. And again, this stuff usually I don't bat an eye about. I'll be honest. When that came up in Murdoch, you guys remember that? That was, that they said that there was some sort of misconduct with the clerk in Murdoch. When that first happened, I thought the same thing. I'm like, here we go again. A bunch of this nonsense. Somebody gets prosecuted and convicted, and all of a sudden the jury was, up to some sort of hanky-panky. And it wasn't until I actually read the pleadings in that case and saw what was being alleged that I thought, oh, hold on a second. This has actually got some teeth to it. But I had the same reaction here to Benefield. I thought, are you kidding me? Like, what are we saying now? That they saw some news report that they I don't know, they told their family member what case they were sitting on. Again, even stuff that might be quote unquote against the rules doesn't necessarily mean you should throw out the entire verdict. I don't know if I would be a fabulous judge, but thank you, Victoria. I would like the power, though. I would like to do it for a day, but I don't think I'd be a fabulous judge after that. So she makes this jury misconduct, and there was two things that came out. One was salacious, and then one was kind of typical. The salacious one was the idea that during a law and crime stream verdict watch of this case, someone going by the name of that hoodie guy made the comment, my sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter. Okay. Now that person didn't come forward, but someone who saw that comment captured that comment and brought it to the defense and said, look, this is evidence that somehow communications were taking place with jurors. A lot of problems with this to begin with. One, no one knows who that hoodie guy is. I understand there's been a lot of internet sleuthing to try to figure it out. Two, that hoodie guy could have been making the whole thing up. Three, even if there was some communication, and this is a lot, but even if there was some communication between someone from the outside and a juror, as bad as that may be, all the jurors are going to be questioned about, did that affect your verdict? Because this person isn't saying, I'm going to blow this whole trial. I'm going to turn it towards the prosecution, even though I believe she's innocent or anything like that. It's just saying, hey, here's where we're leaning. Again, bad, but enough to overturn a conviction? I don't think so. So that one, I think, had it just remained that, a bunch of jurors would be questioned, and they would say, no, it didn't affect us. We don't know what you're talking about. Nobody had a phone. If anybody did have a phone, it didn't change my verdict. And, you know, Bob's your uncle and we're on our way. But what the other part of this that was interesting is that they also said that one of the jurors, and they identified this person as juror number 15, was not truthful on their questionnaire. And that's the one that's a little bit more interesting to me. And again, usually I would say on these things, kind of a big so what, because jurors, you know, they fill out these entire questionnaires and sometimes they forget stuff. Sometimes they're not quite sure what the question is asking. I mean, sometimes these questions can be vague. Have you ever had any interaction with law enforcement and they forget that they got a speeding ticket and that counts, but they didn't put that down there? They're thinking about, have you ever been arrested? And then on and on and on. So I've seen this before. I've actually experienced this before, where we felt like a juror did not disclose everything on a jury questionnaire. One of my favorites is you'll ask a question of, you know, what does your spouse do for a living, retired? And that may be true, but they don't mention to you that they're a retired homicide detective. You know, so it's like, are they being untruthful? Are they keeping information from you? Or is that just you didn't ask a question with enough follow-up questions? And that's the other point kind of being made about this, is that just because it's on a questionnaire doesn't absolve the parties from asking follow-up questions or asking, you know, someone to, you know, we've asked this question, but I'll ask it again. Now, let's get into why this is interesting, and then we'll talk about what may have happened. Okay. Apparently, this one juror claimed to have no experience with domestic violence courts or custody arguments. There is apparently, that was one of the questions, and that person either checked a box or said no. Now, Benefield's attorneys are saying that juror was served with an injunction during a custody battle and was also identified as a victim in several domestic violence cases. Okay. That's a little different, because that is hard to imagine as being something that you would overlook or not understand the question as to why you probably would need to be forthcoming on something like that. Because, by the way, when they're filling out these questionnaires, they also know what this case is about a little bit. They know it's a murder charge. They know it's a charge of probably a spouse on spouse murder. So they know that it's important. They're not just asking about domestic violence in general just for giggles. They're asking because it has to do with whether or not you're appropriate to sit on this trial. And for them to be saying, I didn't realize what that question meant, or I was confused by that question, and that's why I didn't answer it the way I did. Now the wiggle room there is getting a little less wiggly, little less room for the wiggle when it comes to a question like this. And then this came out today, or not today, but recently. This is a notice of appearance on behalf of that juror from an attorney. So this juror has lawyered up. And you might say, well, listen, the person got themselves identified by number, and now everybody's been able to identify who that person is. You know, of course they're going to lawyer up. And I agree with that. People lawyer up for any number of reasons. I would probably lawyer up in this situation just to make sure I'm not getting into any kind of trouble. But here's the part of it that raised some eyebrows with me. I guess one eyebrow. If it was both eyebrows, it wouldn't be as curious. But the undersigned has reviewed all documents filed post-trial by both the state and the defendant and has been unable to locate a copy of, they give this person's name, I'm just going to leave it off, jury questionnaire. In her motion for a new trial, the defendant claims that this person failed to disclose on her questionnaire material information. The court has granted the defendant's request to interview the jurors, and this juror has every intention of cooperating and answering all of the court's questions. In order to fully prepare, this juror and the undersigned request that the questionnaire at issue be provided to the undersigned by September 27th of 2024. Could this again be innocent? Perhaps. Perhaps you know that they've already disclosed what the issue is. They've already disclosed that you're going to be questioned about this. They've already disclosed that they feel that you're lying about this. And you, as any person would, if you're going to be, examined about this, want to make sure that you've got all your ducks in a row and want to see what the question actually was before you start answering questions about it. Could be that, absolutely. And I'm making a bigger deal out of this than is necessary. But you put on top of the person hired a lawyer. Now they want to see what they're going to be questioned about. The idea that this is not one of those questions that is something you could see them overlooking, according to them, being both served with an injunction and identified as a victim in, quote, several domestic violence cases. And that this has to do with an issue that is central to this entire case. This is why it's important, folks. Had she said yes, I was the victim of domestic violence several times, she probably would have been kicked, this juror. So this juror, it could be argued, and the defense is going to argue it. I'm not going to argue it, but the defense is going to argue was untruthful on purpose to avoid being kicked so that they could remain on the jury in a case that actually meant something to them because it's about domestic violence. That's about how far the defense wants to take this. Now, how will this actually play out? Tina says the judge said he was going to tell her to lawyer up. I don't want to make too much noise about lawyering up, but yeah, lawyering up is smart anytime you're probably going to go into court for anything, by the way. So lawyering up is, of all the concerns here, just the one that kind of begins for me to take another look. Lawyering up and then saying, I want to know what this question actually said, and then lawyering up and the question has to do with the heart of the issue is where we get more and more trouble. Yeah. Kaylin, if we got more questions on this, please give them to me. Anyhow, I will this actually turn into a reversal and a new trial for Benefield? I don't know. Again, it really is going to depend on what they're able to prove and what this person, if it looks like to the judge that this person was just lying. I mean, what is their explanation? You were the victim, according to the defense, if this is in fact true, of multiple domestic violence cases. That didn't enter your mind. And if her answer is simply something along the lines of, I forgot, I don't know if the judge goes for that. But if it was, it was an inartfully worded question, the question really says, were you ever the party to a domestic violence case? And they don't know what party means. And it was a, confusing question or something along those lines, maybe, but this could be problematic. Now, what does that mean as far as this case moving forward? Well, if the judge determines that that person lied, I mean, one of the remedies available to the judge would have to be a retrial on this. Is he going to get that far? I do not think so. We're still very early on in this. He's going to do inquiries to these people. It's going to be done privately, so we'll have more information later. But if I were the defense and I felt that somebody had lied to get onto that jury and they had lied about something so central, this isn't lying about your age. This isn't lying about your weight. This isn't lying about, something immaterial to the actual case. This is something that may have gotten you kicked had you been honest about it. What if the DV was in another state and the juror assumed it wasn't relevant in Florida? I mean, again, I don't know if that's a great answer, but that's at least an answer that maybe the judge can hang their hat on and say, okay, well, this person didn't quite understand. And again, I've seen these questionnaires many, many times, and sometimes they are they're not written well. And there is a lot of room for confusion. Sometimes they're not written by the lawyers, by the way. Sometimes they're written by the judge, and the judge is not thinking about all the issues that the lawyers are. What if the juror pleads the fifth? Could she face charges? That's a great question too. I mean, these questionnaires are not signed under penalty of perjury, but you take an oath when you go into jury selection to tell everything truthfully. Could there be an argument that this is perjury, that this is... certainly, I think the answer to that question, Taryn, is if it was somehow proved, and we're way away from that, but if it was somehow proved that this was intentional deceit to get onto that jury to affect the verdict, absolutely they could be charged with a crime. Will they take the fifth? They might. It doesn't mean that necessarily a crime's coming, but it might just be, she's got a lawyer. The lawyer may take a look at that question, say there's no way anybody could be confused by that. There's no way you could forget being the victim of domestic violence. I'm going to tell you to take the fifth on this thing. And it may just end there with a lot of embarrassment and chaos for the Benefield case. Robin says, but wouldn't a DV victim be more helpful to the defense, or were they the aggressor? That's a great question too. I think if you're the defendant, you're obviously arguing that no matter who this person was, you would have likely have kicked them off. I don't know. They may say that, yeah, I understand that she was saying she was a victim and therefore wouldn't victims have been helpful to them. It also may be a situation where they would say, well, we don't want victims of domestic violence because we don't want them placing themselves in the position of our client because they were the victims and they didn't kill anybody. And maybe that will, not line up well. You're right. The idea may get a little hazy as to whether or not they would have kicked them, but I guarantee you the defense would say it's not the question of would we have kicked them. It's the question of we needed to know that information and we weren't given it because of this deception. Jimmy. Hey, Jimmy, how are you doing? Jimmy McNutty says the manslaughter verdict was good for the ballerina. She got the lesser guilty verdict. Does the defense really want to go back into second-degree murder territory? Also a good question. Are they playing with fire here? Do they really want another bite at this apple, or should they look at that as a win for them? Great question. I mean, you're right. Sometimes you can be so intent on winning that you don't really realize, do you want to win? Obviously, if they're going this far, I think they want it. I don't think they're going to go this far, realize there's, let's see this out. Do they make this argument? Do they find out there's jury misconduct? And then do they say, well, you know what? We're going to say we're okay with misconduct in spite of all of that because, we don't want to take our chances again. At that point, I think they've passed the Rubicon, and I think the judge would say, if it goes that far, and again, we're a far way from that, but if it goes that far, I think the judge would say, I have to order a retrial on this. This was misconduct. Have you ever seen an attorney picked to serve on a jury? Yes, I've actually picked attorneys to be on a jury. I've never been picked to be on a jury. I will say that a lot of people say it's a bad idea. I've had some good luck with it, but I do know this, that every time the jury an attorney was on my jury, I knew that that would be my foreperson for sure. Is jury misconduct usually pro forma after a conviction? If they find something, but they got to find something. But that's why I'm saying that usually when these come up, it's a little bit of a yawn for me, because usually there's absolutely nothing to them. It has to do with, oh, you know, somebody watched a news program or saw an article or told their cousin at a barbecue what case they were sitting on, and it really doesn't affect the jury. Can you explain why her main case attorney is filing this? Her appellate attorney involved too? I imagine so. Lee asked a great question. The main attorney is filing it, though, because I think it's still a trial court level issue. The issue is jury misconduct. Judge, please essentially declare a mistrial and ask this to go back again. It's not so much a appeal. Now, if this judge denies it, if there's evidence of misconduct and the judge denies the request for a new trial, then they would appeal that, and then her appellate attorney would be involved in that, is likely how it would go, if it even goes all that far. All right, guys, we're getting towards the end of our hour here. I realized I kind of blew past the Madden thing without asking if you guys had any questions on that. I don't know if, Kaylin, you saved any of the questions, or if you guys still have questions or anything more on Sarah Boone or Benefield, or how it is having 3 girls in the house. Please ask them now. Madeline says, how mad is the defense attorney at his client at this? Is this this is on Madden, I'm guessing. I don't know if he's mad with him or if he's just beside himself. I mean, you know, the guy's just, the attorney, I'm saying, is probably just trying to do his job. He probably realized, I mean, this is a case that it sounds like, aside from this confession, is a very solid case. So it's not like he took a beautiful, wrapped up defense that they thought they had a real winning chance with and blew it the first day in court. It sounds like this thing was going down with the ship anyways. Why didn't his lawyer stop him? That's a great question, Schultz Becky. You know what? When I was looking at the video, it appears as though he didn't realize what was going on. Then again, this is also the guy that's threatened to assault his attorney before. I don't know if it's the same attorney, so maybe they just stay out of his way. But if that were my client, you can be sure I would be grabbing him by the collar and telling him to shut up and turn around. But I don't know. It seemed to me as though it was kind of organically happening, and they might not have even known what he was doing. I mean, you know, sometimes they turn and face the family and they're just, I love you, crying, but rarely does it start to be, I'm so sorry for what I did. Alicia says, Josh, might Madden have admitted it as a ploy to bolster an insanity defense? He might think that, but that's not going anywhere. Absolutely no chance of that. All right, guys. This has been fun. This has been real. You all are the best. I've enjoyed this all again. Couple of announcements coming up for next week. First of all, please, we put up polls about what you guys might want to talk about. And I want you to know, we really do pay attention to them, because there's a lot of stuff happening and there's a lot of cases going on. And we try to stay on top of all of them, but sometimes we don't. And sometimes we don't know what you guys are really interested in. So when we have those polls, please, we really truly do appreciate, and we pay attention to the stuff that you guys are interested in. We just had on Monday our new case notes, the murder of Tupac Shakur. If you guys haven't seen that, please check it out. I'm very proud of it. Kaylin did a tremendous amount of work on it and found some video footage that you can, I didn't know it even existed. So that's really worth checking out. 3 girls in the house. I could hardly deal with one. Yeah, I just kind of stay in my corner and do as I'm told till this all blows over in 30 years. But please check out the Tupac murder one. Also, if you guys haven't noticed, we've had a real uptick in subscribers, and so we welcome all of you new subscribers. If you're making it to this first live tonight, it's been fantastic. A lot of that had to do with some videos and coverage that we did on Diddy. So as soon as we have more developments on that, we will absolutely be sharing more information on that. But we're very proud of the growth of this channel, and it's all because of you guys. We're over 7,000 subscribers now. So, you know, that's fantastic. Thank you again. We have a members only live coming up on Saturday. We're doing this every month. It was a lot of fun last time. If you guys weren't able to join, please try to join this time around for new subscribers as well. It's worth almost being a subscriber just for these chats, because we get into kind of just more, you know, just talking about my life as a prosecutor, family life, answering a bunch of questions. It's just kind of free form, free for all, and we have a lot of fun. And then on Monday, our next episode in our 5 Things series is for this case that you guys may have heard of. It's about to start trial soon. It's about a woman by the name of Sarah Boone, who zipped up her boyfriend in a suitcase. And if you guys haven't heard about that, you're going to hear about 5 things you need to know about that case before the trial begins, coming up very soon. But in the meantime, you all are wonderful. This has been wonderful. I got to go back to daddy duty. Thank you so much for joining me. I hope you guys have a wonderful week, and I will see you all again next weekend. Take care, you guys.